The courtroom had 40 people in it when my husband said it. His attorney. Mine. A court reporter. A bailiff. 2 rows of gallery seating with family members on both sides. The judge had just asked Richard to clarify his position on the asset division, and Richard leaned toward his microphone and said, "Take your brat and go to hell." Exactly those words. The court reporter's fingers stopped moving. The bailiff straightened. Richard's own attorney put his pen down and looked at the ceiling. The judge did not react immediately. She looked at Richard for a long moment. Then she looked down at the document in front of her and said, "I'd like to address the inheritance disclosure. I need to tell you about the inheritance before I tell you about the trial. My grandmother on my mother's side was a woman named Ruth. She was born in rural Georgia in 1938, and she spent the first 40 years of her life being told, in various ways and by various people, that she was not someone who would amount to anything in particular. She proved them wrong in the quiet and specific way that certain people prove things, not loudly, not with speeches, but by making decisions over decades that accumulated into something undeniable. She invested carefully. She bought land when land in her county was affordable. She held what she bought. She did not discuss her finances with anyone, which was a habit born of experience, and which she maintained until the week she died. She left me $940,000. I was 34 when she died. I had been married to Richard for 6 years. I did not tell him about the inheritance immediately, and the reason I did not tell him is something I have thought about carefully since, because it tells me something true about the state of my marriage at that point that I had been refusing to acknowledge. I did not tell him because I did not trust him. Not with money. Not with information about money. Not with anything that gave him additional leverage in an arrangement that already felt, if I am being precise about it, significantly tilted. My name is Miriam. I am 37 now. I have a daughter named Cora, who is 7 and who draws horses on every available surface, and who has her great-grandmother's eyes and her great-grandmother's particular quality of watching a room before deciding what she thinks about it. Cora is the reason the last 3 years happened the way they happened, and the reason I made every decision I made, and the reason the word brat, said into a courtroom microphone by a man who was supposed to love her, landed in my chest the way it landed and did not break me. Richard and I met when I was 28. He was charming in the way that some men are charming, effortlessly, generously, in a way that made you feel attended to in rooms that had not always attended to you. I was a paralegal then, working long hours at a firm in Atlanta, living in an apartment I liked but couldn't fully afford. He was in commercial real estate. He had money and ease and the particular confidence of someone who had never had to argue for his own credibility. I found that confidence attractive. It took me several years to understand the difference between confidence and the assumption that you are entitled to occupy more space than you actually earn. The marriage started well enough, or appeared to. The first signal I can identify with precision came when Cora was 8 months old. I had returned to work part-time and Richard had, without discussion, restructured our joint finances so that my income went into a household account he managed and my access to that account required a conversation with him about what I needed. He framed it as organization. He said it made things simpler. He presented it with the easy certainty of someone describing an administrative decision rather than a fundamental shift in the power arrangement of a household. I asked questions. He gave answers that made enough surface sense that I accepted them. Then I went back to work and came home and took care of Cora, and filed the unease away in the same place I had been filing things since before I could name what they were. The second signal came when I mentioned, during a difficult month, that I had some savings from before the marriage that I could access if we needed them. Richard asked how much. I gave him a figure, smaller than the truth, and he nodded and said, "Don't touch it yet, we'll be fine." The fact that he decided, in that sentence, when I could access my own premarital savings, did not register as clearly as it should have. It registered later. The third signal was the conversation about my grandmother. Ruth had been ill for 2 years before she died. I visited when I could, which was not as often as I wanted, because Richard had opinions about how often I traveled without him, and how much the trips cost, and what it meant for Cora's routine. When Ruth died, I flew to Georgia alone, and I sat, with my mother and aunts in the house my grandmother had kept for 50 years, and I learned the contents of the will from a family attorney in a small office, with good light, and wood-paneled walls. I sat with that number for a long time before I flew home. I did not tell Richard. I opened a private account at a bank he had no connection to. I transferred the inheritance within 30 days of its disbursement. I sat on it for 3 years, through the deterioration of a marriage I was still, at that point, hoping might be salvaged, until the morning I found the emails between Richard and his attorney and understood that salvage was no longer the relevant framework. Then I called my own attorney. The divorce filing happened on a Tuesday in March. Diane filed on my behalf at 9 in the morning. I was at work when it was processed, sitting at my desk with a full calendar of the ordinary administrative tasks that had structured my days for years. And my phone buzzed once with a message from Diane that said simply, "It's filed." I read the message. I set the phone face down. I finished the task I was in the middle of. Then I went to the break room and made coffee, and stood by the window for a few minutes looking at the street below, and letting the fact of it settle into something real. Richard was served that afternoon. He called me 4 times before 6 o'clock. I let each call go to voicemail. His messages moved through the sequence I had anticipated: surprise in the first one, which I did not believe, a request to talk in the second, a shift toward negotiation in the third, and in the fourth, the first appearance of the voice I had learned to recognize over 6 years as the one that emerged when the manageable version of a situation had stopped working. Controlled, but with something harder underneath it. He said he hoped I understood what I was doing. He said it would be better for everyone, especially Cora, if we handled this like adults. I noted the "especially Cora" and forwarded the voicemail to Diane. The pre-trial period lasted 4 months. During those 4 months, Richard's attorney pursued the custody argument with the energy of someone who believed it was their strongest position, which meant it had been designed to be their strongest position, and the emails had told me exactly how it was designed. They requested school records. They requested medical records from the period of my illness. They filed a motion requesting a guardian ad litem evaluation that Diane said was a standard pressure tactic in proceedings, where one party believed the other would become destabilized by the process and make errors. I did not become destabilized. I went to work. I came home. I made Cora's dinner, and helped with her homework, and sat beside her while she drew horses on the back of her school folders, and told me about her day with the unhurried thoroughness of a 7-year-old who trusts that her audience is fully present. I was fully present. That was the one thing Richard's attorney could not document otherwise, no matter how many records they requested. The inheritance question surfaced formally in the 3rd month. Richard's attorney submitted an asset disclosure request that was standard in scope, covering all accounts held individually or jointly from the date of marriage forward. Diane responded with the disclosure I had prepared, which listed the private account and its current balance, the $940,000, grown over 3 years of careful and unspectacular investment, to $1,072,000. Richard's response to the disclosure was not immediate. Diane told me there had been a recess called in a scheduling meeting when the number was presented. She said it with the dry professionalism of someone who had seen many rooms reorganize around financial information, and had learned to describe it in neutral language. The custody strategy shifted within 2 weeks of the disclosure. The guardian ad litem request was quietly withdrawn. The tone of correspondence from Richard's attorney became more measured. The word amicable appeared for the first time. I had been watching for that word. It arrives, in contested proceedings, at the precise moment the less documented party understands the landscape has changed. The trial date held. Richard chose not to settle, which Diane said sometimes happened when a person's primary motivation was not the outcome, but the performance of the outcome, the opportunity to say things in a room that required a record. I understood that. It fit everything I knew about him. The morning of the trial I dropped Cora at my mother's house. My mother held my hands at the door and said something I have not forgotten. She said, "Ruth would want you to be steady today." I said, "I know." She said, "You already are." I got in my car. I wore a charcoal blazer I had bought specifically for professional appearances that required people to take me seriously at first sight. I wore it the way I wore everything on days that mattered, carefully, intentionally, with the understanding that how you present yourself in a room communicates something before you have said a single word. I sat at the plaintiff's table beside Diane, and I folded my hands and I waited. Richard arrived 7 minutes before the session was called. He sat across the aisle and he did not look at me and I did not look at him. The room filled in around us. The bailiff called order. The judge entered and took her seat and looked at both tables with the even attention of someone who had heard many versions of this particular story and intended to hear this one without predetermined conclusions. She asked Richard to clarify his position on the asset division. He leaned toward his microphone. And then he said what he said. The room held very still for approximately 4 seconds after Richard spoke. I counted them. Not deliberately. The way you count things, when your mind needs something to do while the rest of you absorbs what has just happened. The court reporter looked at her machine. The bailiff looked at the wall. Richard's attorney placed both hands flat on the table in front of him, with the careful deliberateness of someone trying to physically anchor himself to a surface. Richard sat back in his chair as though the words had cost him nothing, which told me everything about where he had arrived. The judge looked at him. She said, "Mr. Calloway, I'm going to ask that you refrain from that kind of language in my courtroom." Then she looked down at the document in front of her and said, "I'd like to address the inheritance disclosure." That was all she said before the room reorganized itself. I had spoken to Diane at length about how the inheritance would be characterized. Georgia law distinguishes between marital and separate property, and an inheritance received during a marriage from a family member and kept in a separately maintained account with no commingling of marital funds occupies a specific and protected legal category. Diane had documented every element of that protection with the thoroughness she brought to everything. The account's origin. The dates. The source. The 3 years of clean separation. The judge reviewed the documentation for 11 minutes in the silence of a room that was not speaking. Richard's attorney made 2 arguments. Diane addressed both in the precise, unhurried manner of someone who has anticipated the counterarguments and prepared for them specifically. The judge asked 3 clarifying questions. Diane answered each one. The inheritance was classified as separate property. Richard received none of it. The custody arrangement gave me primary physical custody of Cora, with structured visitation for Richard, which was the outcome Diane had told me was most consistent with the evidence, and which the withdrawal of the guardian ad litem motion had made significantly more straightforward to achieve. The word brat, spoken into a court microphone in front of a sitting judge, did not help Richard's case in any direction. His attorney, to his credit, appeared to understand that in real time. The trial concluded by mid-afternoon. I shook Diane's hand in the courthouse corridor, and she said I had done well, and I said she had done better, and she allowed herself a small, satisfied expression that was the closest I had seen her come to celebration. I walked to my car. I sat in it for a few minutes in the parking garage before starting the engine. I thought about Ruth. I thought about the small office with the wood-paneled walls and the family attorney, and the number that had reorganized my understanding of my grandmother's quiet and private life. I thought about the decision she had made to keep her own counsel for 50 years, to hold what she built without discussing it with anyone, to arrive at the end of her life having accumulated something real and undeniable. I had made the same decision for 3 years. It had felt, at times, like secrecy. It had felt like withholding. There had been moments in the middle of the marriage, during the difficult periods when I had wanted to believe things could be different, when I had wondered whether keeping the inheritance private was itself a kind of choice I needed to examine. Sitting in that parking garage, I understood it as something simpler. It was an instinct toward self-preservation in a situation that had been asking me, gradually and systematically, to give up the parts of myself that were most my own. I had held one thing back. That one thing had held me in place when everything else was being contested. I drove to my mother's house to get Cora. She was in the backyard when I arrived, drawing with chalk on the patio stones. Not horses this time. She had drawn a house, 4 walls, a door, 2 windows, a large sun in the corner the way children draw suns, a circle with lines extending outward like it is trying to reach everything at once. She saw me come through the gate and she stood up and she said, "Mama, look, I made us a house." I looked at it. I said it was the best house I had ever seen. She said it needed more colors and picked up a green piece of chalk and kept going. I sat on the back steps and watched her work in the late afternoon light, and I did not think about the courtroom, or Richard, or the 4 seconds of silence, or anything that had happened in the last 4 months. I just watched my daughter draw. The apartment we moved into 6 weeks later had a small patio. It was not large. It was in a neighborhood I liked, close to Cora's school, with enough room for 2 people to live comfortably without feeling the particular kind of pressure that comes from too much space that doesn't belong to you. Cora asked if she could draw on the patio. I said yes. She started the following morning. The private account remained in my name. The inheritance, intact except for legal fees and the first and last month of the apartment lease, sat in the same place it had sat for 3 years, steady, documented, entirely mine. Ruth had wanted it used for something that lasted. I was still deciding exactly what that looked like. There was no rush. I had learned, from watching my grandmother's life and from the specific education of the last 4 years, that the decisions that lasted were the ones made carefully, and without pressure, and from a position of genuine stability rather than urgency. I had stability. Real stability. The kind that didn't depend on anyone's approval, or participation, or good behavior. Richard's commercial real estate practice contracted in the year that followed. He left Atlanta eventually, which I heard from mutual acquaintances, who mentioned it the way people mention things they expect you to have feelings about. I did not have strong feelings about it. I had Cora and work and a patio covered in chalk drawings that got rained on and faded and were redrawn the following morning in slightly different configurations. Cora asked about her father in the way 7-year-olds ask, directly, without strategy, in the middle of unrelated moments. I answered with the truth at the level she could hold. She absorbed it the way she absorbed most things. Seriously, briefly, and then forward. She was Ruth's great-granddaughter. That quality was in her, the watching before deciding, the stillness before the assessment. I recognized it and I did not try to shape it into anything else. I let it be what it was. Diane sent me a brief note 6 months after the trial. She said she hoped we were well. She said she occasionally thought about the case as one that had gone exactly as it should, which she noted was not always the experience. I wrote back. I told her we were well. I told her Cora had recently decided that horses needed more colors than they were usually given, and had started drawing them in combinations that were not available in nature. I told her Ruth would have liked that. I believed it. My grandmother had spent her whole life proving that things could hold more than people assumed they could. More value. More weight. More color. She had done it quietly, without announcement, in the patient way of someone who understood that the work was its own evidence, and the evidence would eventually speak for itself. The chalk drawing of the house was still on the patio in Atlanta. My mother had photographed it before we moved. I had printed the photograph. It was on the wall of Cora's room in the new apartment, framed in plain wood, beside a drawing she had made of a purple horse looking calmly at something outside the frame. I liked the purple horse. It looked like it knew exactly where it was going.